Hello everyone and welcome to our talk on law. I'm Tiffany and this is Alfie, and today we have two amazing speakers, both very highly regarded and highly respected in the legal profession. Firstly, we have Miss Stephanie Boyce. Miss Boyce is the Vice President of the Law Society and will become President later this year. Miss Boyce has had a very interesting and diverse legal career, which includes being a former interim general counsel, a strategic partner, director, and consultant.
We also have Judge Ian Darling. He attended Winchester College and King's College London, where he took the double LB honours course. He did a year's pupillage, followed by a long-term tenancy at 2 Harcourt buildings. From 1999, his practice largely consisted of prosecuting murders at the Central Criminal Court, the Old Bailey. After becoming a recorder in 2003, he looked for a more senior role in the legal system, and in 2009, he became a circuit judge.
I will now welcome Miss Boyce to talk about the law, becoming a solicitor, her own experiences, and the Law Society.
Well, thank you very much. Can you hear me?
Yes, we can.
Good. So, good evening. It's an absolute pleasure to be speaking to you all, and I am delighted that technology allows us to come together virtually. So my name is Stephanie Boyce, and yes, I'm the Vice President of the Law Society of England and Wales. And the Law Society is the representative body for over 200,000 solicitors across England and Wales. So I'm going to speak today about the law, the rule of law, and my journey into becoming a solicitor. So what do we think of when we think of the law? Is it enrobed judges wearing wigs, debating fine constitutional points in grand rooms? Politicians debating in Parliament on what law next to pass? Or courtroom or police dramas on TV like Line of Duty? All of these things are true, but the law goes much further. The law underpins our society. It touches every aspect of our daily lives without us even noticing. You walk down any street, each building will have been built subject to planning law. Houses will have been bought and sold using lawyers. Shops subject to wide-ranging laws on sale of goods, and so on and so on. And the high street is just one example beyond it. Law underpins the work of all businesses, of international trade, of global politics. The law is a fascinating arena, constantly changing and evolving. And as society modernizes with rapidly developing technology, new challenges will continue to present themselves. But that is the future. And I want to start by talking about the past and our understanding of the law, and more specifically, the rule of law, a great British value. Some 804 years ago, in boggy fields in Runnymede, King John reluctantly gave credence to the idea that everybody, including the monarch, should be subject to the law of the land. And thus the rule of law was born as common law principle of governance, which guarantees that nobody, not the most highly placed official, nor the government itself, is above the law. And it was famously written, "To no one will we sell, to no one will we deny or delay right or justice." While there is no one precise definition of the rule of law, there is broad agreement upon its key tenets. And these are the existence of legal constraints on the power of the state, an ability to enforce those rights and hold the state accountable, and the equal application of the law to all. The Law Society of England and Wales has adopted the United Nations system's definition of the rule of law as a principle of governance in which all persons, institutions, and entities, public and private, including the state itself, are accountable to laws that are publicly promulgated, equally enforced, and independently adjudicated, and which are consistent with international human rights, norms, and standards. Lawyers play a key role in constructing and upholding the rule of law. And we do this by building the institutions and culture of the rule of law through an emphasis on the forms and procedures of legality and due process, and by championing an independent and impartial judiciary. This helps to entrench the cultural norms of respect for and resort to law and legal authorities, and a consciousness of individual rights amongst citizens. By defending fundamental rights, such as freedom of speech, assembly, and public participation, as well as protection against arbitrary arrest and imprisonment, and the protection of minorities from prosecution and discrimination. And finally, by building and maintaining legal regimes that help to sustain property rights, contract enforcement, and efficient forms of business organization. Lawyers use their skills, services, and reasoning, for example, for judicial review of legislative and administrative actions, other types of litigation. Such legal process often serve as limits on states' power, and as a means to make such power accountable and transparent, or at least to put up roadblocks to its arbitrary exercise. They may even deliver powerful tools to the vulnerable to help give equality of arms against stronger private parties and governments. As Rudolf von Neisse, one of the architects of the German profession of advocates, rather grandly put it in 1867, the free practicing bar means nothing less than the precondition for all independence of communal life, of self-government, of constitutional life on the largest scale. Or more simply, liberty, justice, rights. Without lawyers, these are just words. Key to the practical enforcement of this definition are measures to ensure adherence to the principles of supremacy of the law, equality before the law, fairness in the application of the law, and separation of powers. Participation in decision-making, legal certainty, avoidance of arbitrariness, and procedural and legal transparency. The rule of law is fundamental to peace, security, and political stability. It is essential in promoting economic and social progress and in protecting the rights of the individual. It is the rule of law that ensures access to public services, that curbs corruption, that prevents the abuse of power, and that forms part of the social contract between the state and its citizens. It may be instructive at this point to consider how wide the aegis of the rule of law is. Many people quite understandably think of it as interaction with the police or the courts, whereas in fact it encompasses everything we do as members of the legal profession, from great city firms conducting international contract work, to sole practitioners drawing up a will, to the ability of every individual to properly and fairly obtain their rights or understand the liabilities to which they may be subject. The rule of law is not a technology, a module of specific legal practices that can simply be implanted in a society and expected to start working as advertised, grinding out predictable enforcement of legal rules, which in turn generates compliance with those rules. So let me share with you a little bit about my route into the profession. So before I took up my role as an office holder of the Law Society of England and Wales in July 2019, I had a somewhat unorthodox route into the profession. In 1985, my family relocated to the United States of America. And even though I lived there for the next 6 years, I always knew I would return to the UK to study law. So in 1991, the day after finishing high school, I returned to the UK and so began my legal career. But I stumbled across my first barrier upon discovering that my US qualification would not be recognised in the UK at that time. However, thanks to the access to higher qualification route, I was able to enter London Guildhall University, as it was so that called, in 1996, where I graduated in 1999 with an LLB honours in politics. And after that, I progressed to the College of Law in Guildford to undertake the legal practice course. Securing a training contract was not an easy task. However, thanks to the steadfast encouragement of my father, I was able to secure a placement with a local firm in the town in which I still live. So I qualified in 2002, and a few years later, I left private practice and went and joined my first in-house team. In 2010, I completed a Master's of Law, a Master's degree in Public Law and Global Governance at King's College, University of London. And 9 years later, or thereabouts, I was elected to become a council member onto the Law Society's, 9 years later, I was elected to become a member of the Law Society's presidential team. And in doing so, I represent a couple of firsts. I'm the first Black office holder, the first person of colour to hold the position of president, and the second in-house solicitor to be an elected office holder in almost 50 years. I hope to bring a fresh perspective and understanding of the experiences of those underrepresented groups and what we must all do to support them. I also hope that through my experiences and that of many of our members, to provide proof that no matter what the challenge or how insurmountable the odds appear to be, it is possible to succeed if you are determined and passionate. So, as I said, the Law Society is the independent body for solicitors in England and Wales. And our purpose is to be the voice of solicitors, to drive excellence in the profession and to safeguard the rule of law. And we do this by influencing for impact by speaking out for justice on legal issues, driving professional excellence by helping solicitors to develop their expertise and their businesses, whether they work in firms, in private practice, in-house, in big, small legal departments, or indeed on their own account for themselves. And this includes working to ensure that the best talent can join the profession, irrespective of their background, and supporting equality, diversity, and inclusion in the solicitor and legal profession. We're here to help current and future members, supporting them at every stage of their career. The legal profession has always been adaptable and capable of responding to changing circumstances and new circumstances, new challenges. And this has been apparent in the sector's response to coronavirus. We always find ways to innovate and ensure we continue to provide the highest quality services to our clients. I hope that in the years to come, some of you will be entering the profession, undertaking training, and then be in the early stages of your careers. If so, you will be faced with unprecedented challenges, unlike those anyone has faced before, and certainly unlike what has been faced by your predecessors in years gone by. Indeed, you have already experienced, perhaps, the need to adapt to the way in which you are studying, such as having to study remotely due to the impact of the COVID-19 pandemic. The resilience you have shown already in being able to adapt will serve you well in your future careers. And although the challenges are significant, the solicitors of the future play an important part in shaping what the profession and the provision of legal services will look like in the years to come. And the Law Society is here to support you and those who want to follow such a path at every stage of their career. And some of you may know a little about the Law Society and the role we play already, but I'm keeping you from hearing the wisdom of Judge Ian Darling, which I too am eager to listen to. So I will hand over to him now, and I look forward to answering your questions thereafter. Thank you very much.
Yes. Can everyone hear me? Good. Well, at the outset, can I say thank you very much for inviting me to talk to you this evening. And can I say, following Stephanie is a rather hard act to follow, because listening to her made me realize just how big a concept the world of law really is and what it stands for. And that's not to say you don't realize that from the day you begin your legal career, but when you're at the coalface, you sometimes don't stop long enough to think just how important a role you are playing within something so fundamental to our society. I adopt and endorse everything Stephanie says about the importance and fundamentality of it. Stephanie's given you her route into her extremely lofty position within the legal profession, and it was an honor to hear what she had to say. I thought I might give you perhaps a roll up your sleeves version of how I got to where I am today. And it's perhaps of some value because it probably will expose and highlight the differences that exist now to then, why those differences make it better now as opposed to then. And I hope will reflect how, as Stephanie has said, the law adapts to change and is for always seeking to not just self-regulate, but to improve and to strive for excellence. I would like to say that I came to law as a dyed-in-the-wool committed barrister, which is what I became, from the day that I was old enough to watch whatever black and white TV program was doing the rounds then. But it wasn't like that. I left Winchester College with the high and mighty collection of 2Bs and 2Cs at A-level, which I assure you the marking was a bit different back in those days, but I didn't know what to do. I'd been a linguist at school, but wasn't a natural linguist. I simply couldn't do science. I was scared of economics because it seemed to me to be all mathematical. And so when it came to university and things weren't remotely as structured as they are now, I thought I'll do a law degree because a law degree seems to be a multi-purpose, fits a lot of different types of jobs, industry, the city. I really had no idea. All I really knew at that stage of my life was that I wanted to be an actor, and was going to be an actor, which, although that didn't happen for a number of reasons, would explain why I was always leaning, if that's where I ended up, to being a barrister as opposed to a solicitor, because back in those days, and I'm talking about in the early to mid 80s, the only way pretty much to do regular advocacy was to be a barrister. But still, it was just a means to an end at that stage. I was just trying to get a degree that would work. And when I went to King's College London, it was a bit like doing a law degree. I'm a lawyer, but it was a bit like a mixture between GCSEs, as they're now called, and A-levels. There was quite a lot of learning by rote, and repeating it just to show you know it. Contract, tax rules, all that sort of thing. Crime was learning what the authorities were, how they applied to the law. But there was also a lot of academic sides to the law when I first started to realize just how important law was. Law and politics, law and ethics, law and morals, law and human rights, as Stephanie has already touched upon. It is a fundamental to the core structure with which we live our lives in the way in which we do. But I popped out of university, still not knowing what I wanted to do. And I knew I didn't want to be a solicitor if I was going to be a lawyer. And so I went off to bar school, as it was then called. There was only one actually in those days, the Inns of Court School of Law. And it was sort of halfway through there that I had my epiphany, if you like, because I suddenly realized that what I wanted to do was to be a criminal advocate. And it had started in my, after I left bar school, after I left university, my best friend from school, his girlfriend's father was a QC in London Chambers. And I think it was over lunch one Sunday. He knew what I was doing and he said, did I want to come and see how it worked, the coalface? And I said, yes. And you're probably scratching your head a bit because now everything's so structured and just taken as read. This was a big thing for me. And I was told to present myself at Chambers at 8:45 on a Monday morning. And the senior clerk walked me down to the Old Bailey. And the doors just opened because the senior clerks in those days were the doyens of these sorts of places. And I spent 2 weeks at the Old Bailey sitting behind in 2 different murder trials. And I got the bug. It just was fabulous. I hadn't got it for the deeply philosophical reasons that one might now look back on. I just loved the world. And when it came to applying for pupillage, and this is an indication of how I am an example of the best of times and very much the worst of times, there was no regulatory body that controlled pupillages. The bar was well known, and I hope not so much these days, to be a somewhat self-supporting elitist world. And when it came to applying for pupillages, I literally wrote handwritten letters to, I think, about 7 different sets of chambers, which were recommended to me by people who knew. And I got interviewed by 7 of the 8. I'm afraid to say that high strike rate, 7 out of 8, is as symptomatic of what was wrong with the bar. My CV, not much to it, but it had Winchester College and London University. And I'm afraid that opened doors that now would simply not open for me, and the profession is better for it. I can tell you that. But I was offered a pupillage by a set of chambers, which was thought to be one of the best sets of chambers. But I really wanted to go to the set that I'd done my mini pupillage at during the period between. And I was being pushed to make a decision. And I got a letter, because in those days, mobile phones weren't quite as common as they were soon to become, asking me to ring chambers. So I rang the chambers where I'd done my mini pupillage. And I spoke to a member of Chambers who said, was I still looking for a pupillage? And I said, yeah. And I was. And he said, okay, well, could you come to Chambers at 4:30 next Tuesday and you can meet your pupil master? And that was how I got my pupillage. And I say, I look back in horror. It was to my benefit at the time, but it's just not on. But having got my pupillage, I spent a year going wherever my pupil master told me to go, which happily most of the time was the Old Bailey. But it involved working till 2 in the morning at his house, or sometimes at the Old Bailey. I got made a tenant, and that's the time when pupil barristers and baby tenants go off and learn how to do the job. You go off to a magistrate's court. Even if you're not in a criminal set, the chances are as a pupil you will do some magistrate's court work, because that's how you learn the basic advocacy, although you're now taught it. In my day, there were no such classes. And one thing led to another, and my set with 2 Harcourt buildings was a very well-known prosecution set, but it had a lot of defense work. And I had a 50-50 split, and I worked my way through, and I was lucky to do a series of long cases at the Old Bailey. So my heart was now set on remaining at the Old Bailey. And in 1999, I became there's a thing called Treasury Counsel, senior and junior Treasury Counsel, and they prosecute the serious cases at the Bailey. And that's what I did for the next 10 years. I applied to become a recorder, which is a part-time judge, in 2003, which back then was thought to be rather young to be doing that. And I don't know why I did it, whether it was prestige, whether I thought it's what I ought to be doing. I certainly had no intentions of ever wanting to be a judge. I was busy doing what I was supposed to do as a barrister. And within 2 days of my first week, my first anxious week of sitting as a recorder, as a part-time judge, I suddenly realized that I felt more at ease with myself than I had felt for the last however many years I'd been pitting myself up against the tests, the exams, the career at the bar. And I loved it. And I can't quite describe it, but it just, I'd always felt I had to work that much harder to succeed at whatever I'd done. And this seemed to fit. And then there came a time when I had to make a decision as to which way I was going to go. And it coincided in getting married and having my first child in 2004, when it became apparent that maybe working 6.5 days a week, sometimes till after midnight, night after night, wasn't actually as desirable as I thought it was. And so I applied to become a full-time judge. I was told I was a full-time judge in 2008, but I wasn't sworn in until 2009. But I'd sat for a full year as a recorder permanently. I gave up practice. And it feels like yesterday. The last 11 or 12 years have flown by. Sometimes it's very hard. Sometimes it's not so hard. I work very hard at being a judge, and any judge who tells you that it's not a hard job, they are not telling the truth for whatever reason that might be. But it is simply the most rewarding thing I think I've ever done. I realized, many might disagree with me, but it's something I hold dear, that I can make a difference. People can make differences if they take it seriously. And what being a judge is about is it's not just sentencing people to prison. It's not just being an umpire at a trial, which is effectively what a judge does. It's about seeing real life. As a criminal judge, normally pretty grotty, sad life, or troubled life, or violent life, or hopeless life. And it's trying to make sure that that person gets from the law what they are entitled to. And I assure you that takes quite a lot of working at. And no 2 days are ever the same, be it doing a long trial, a complex, violent murder type case, or a simple handling stolen goods or a burglary. They all are massive cases to the individuals concerned. And a judge has a huge responsibility to make sure that the individual does not get somehow squashed into an obscure vacuum, which can happen. And certainly can be the perception that the public have of the legal system and the judiciary. And I'm going to leave it more or less there, because I suspect there may be some questions, and I think what I do for a living is perhaps best explored by people asking me specific things. But that's that's a little quick trot through how I have got to be where I am. Thank you very much for listening.
Thank you so much. That was great. So now we have a few questions to ask, starting with law degrees. Are there any particular non-law degrees that students could take that you think it would make it easier to become a lawyer? As recently a Supreme Court justice just said that it's preferable not to take a law degree and to take a degree such as history or classics or a language.
Go on, Ian.
From my perspective, and I ran pupillage, by the way, in my chambers for 16 years. I adored reading people's applications who'd done history, who'd done science, because it's all about developing the mind. And as far as I'm concerned, you can certainly be a barrister with whatever degrees you have done, because it's about the creativity that comes to it. And I have to say, some of the most successful criminal advocates I've come across in the last 30 years are ones who turned up with science degrees. I don't quite know why, but maybe there's a sort of aptitude to it. But I mean, history is a very good example. Economics, literature, classics. It's anything is of benefit. It develops your mind and expands your thought processes. So I don't think you need to restrict it to any particular topic. You're just looking for things that widen your mind.
I absolutely agree. I mean, certainly in September 2021 or later this year, the way solicitors train and qualify is changing. So we're moving away from the legal practice course, unless you started it at the LPC or the GDL before September 2021, to the SQE, the Solicitors Qualifying Examination. And of course, one of the things about the SQE is said to remove artificial barriers to entry and diversify the profession more so. And that enables you to have a degree in any subject or qualification or experience that is equivalent to a degree, such as a solicitor apprenticeship, which combines job experience and training all in one. So absolutely, for all the reasons that Ian has amplified, as well as the fact that there is recognition actually that a law degree should not be a prerequisite to entry into the legal profession.
Thank you very much. The second question we have is for both of you, and this is when becoming a barrister or solicitor. On the barrister side, if you cannot get a pupillage or tenancy, what happens? And can you still become a barrister? And on the solicitor side, what happens if you do not receive a training contract? Ms. Boyce, if you'd like to go first.
Sorry, did you say I go first?
Yeah.
Yep. So absolutely. I mean, year on year, law schools, graduate or produce more trainee candidates than they do training contracts available. So absolutely. So the likelihood is there's such fierce competition for the training contracts that are available. And of course, the pandemic perhaps has made things even more worse in terms of the availability of training contracts and the competition for those training contracts. But there's also the solicitor apprenticeship route that I mentioned earlier, which combines over a period of 5 years, training and work experience in one. And of course, you have the apprenticeship training levy, which potentially you could be paid to train and learn whilst working. So there are routes opening up. But of course, competition is quite great.
It's not so very different at the bar.
Thank you very much. Next question, Tiffany.
So there are qualifications that one can take to play both the roles as a solicitor and as a barrister. For example, becoming a solicitor advocate. What does this mean in practice? Have the roles of a barrister and solicitor become the same?
No, I can start with that one. No, they haven't, but not to the detriment of either profession. Solicitor advocates now are extremely, extremely normal. And the bar has had to realize that it is not this elite body that maybe it perceived itself to be back in the day. Solicitor advocates, in terms of criminal work, arrive in a number of different routes. You have the solicitor who wants to do advocacy, and why on earth shouldn't a solicitor do advocacy? Some of the best advocates I've seen in front of me are solicitor advocates, and I enjoy telling the bar that. The bar, you get people who become higher court advocates and effectively join firms of solicitors, but that is for a number of different reasons. It is for that they are fearful that they haven't got the work as a freestanding entity, and they need the protection of a firm of solicitors. And to that end, it's quite funny that the bar then becomes totally dependent on the solicitor, as it were, in many cases to survive. There is no stigma in my mind anymore to whether you are a barrister or a solicitor. The solicitor who has a higher court certificate is every bit as comparable and as able as the barrister. And I don't think people need to worry either way. It's all about what you want to do. And if you want to be an advocate, in many ways, it doesn't matter where your starting point is, providing you've got the stage and the platform to do what you believe in, then you will succeed whether you're a barrister, a solicitor, or a higher courts advocate.
Thank you. Thank you. The next question is that it's becoming more and more common for people to be called to multiple bars. And is it an advantage to be called to the bar for, let's say, France, New York, Ireland?
I think, I mean, certainly, absolutely. We see, and indeed, you know, if you take the Law Society as a body, we belong to a number of bars around in different jurisdictions, and you know, there are a number of reasons for that. You know, and seemingly for the individual, it might be that, you know, you're in a big organization, a global organization, and there is merit in belonging to different bars, associations, you know, to tap into that local knowledge, to be able to perhaps practice in that area. Some bars are closed in terms of who can, if you're not licensed in that jurisdiction, or if you don't live in that jurisdiction, as to whether or not you can practice there. But I think there is merit in sharing that knowledge, that information. Obviously, it depends, going back to what Ian was saying about solicitor advocates and barristers, it depends ultimately what you want to do, what you want to gain from those memberships. So I think it's down to the individual, and then of course it may be down to the employer as to, you know, whether or not they see the merit in belonging to other bars and associations, local law societies, and so forth. But I think the collegiality that you get from being members of those different bars, associations, law societies, is also another factor to consider.
That its relevance really isn't at the outset of your career. If I was chairman of pupillage in my old chambers, I wouldn't have been that impressed if a rookie undergraduate turned up with a qualification to practice in America. It wouldn't have any real impact, but it might change once you were a tenant, and it would give you an extra direction and dimension. So I don't think you need to regard it as an essential at the outset.
Thank you. With recent judicial review cases on government decisions like the Home Office decision to withdraw citizenship from Shamima Begum and Matt Hancock's delay in publishing COVID contracts information, do you think that the judiciary plays a vital part in holding government to account in terms of the law and making sure the government does follow the law?
Ian, I think that's a question for you.
Yes, I do think the judiciary does, but not in a political way with a capital P. The courts simply implement what the law is, and the executive must understand that it is required constitutionally, if I can put it that way, to operate within its powers as have been given to it. I always get a little nervous about the concept of the judiciary involving itself in politics, because as judges we swear an oath of allegiance to the Queen. I forget the words precisely, but it's to do justice to all manner of people without fear of favour. We are supposed to be totally impartial, and we can't do what we do if we're not, and that is why there are strict rules about the politicisation of the judiciary, and indeed judges are not supposed to, as it were, be seen to be putting themselves on any particular political stance, although you don't need to look too hard to see where people do lie. But I think the importance of neutrality in terms of politics and integrity in application of law inevitably gives the impression that we are involved. But we're not really involved in politics. We're just, as it were, setting in a firmer tone that the Constitution allows the government to operate. So we're observers and enforcers, not makers. I'm not sure how clear that is, but it's a sensitive subject, and it's one that in different circumstances I might have a lot more to say about.
Thank you very much. The next question is, if you look at the Supreme Court's judgment on Boris Johnson's prorogation of Parliament, they declared this unlawful. Do you think it was the court's decision or right to make this ruling? And essentially, is there a line between politics and law? And if there is, how do we know if it has been crossed?
I think that question follows on from what Ian was just talking about. The courts are there. Parliament is there to legislate. The courts are there to interpret those laws as best as they can. And I think, as Ian said, it can be a sensitive topic. And we all have seen instances around the globe where perhaps, governments, courts have overstretched their jurisdiction. I think we're lucky in this jurisdiction that we don't have that. And that there are probably more jurisdictions around the world where we don't have that than where we do have it. So I think our courts do a wonderful job. I don't think that they encroach into politics, but I think, as Ian said, it is a sensitive area, and so I think that's as best as I'm going to say on it.
Thank you very much. Ms. Boyce, you talked a lot about the rule of law, which is fascinating. And would you say the rule of law is the most important principle underpinning society today?
I would. As I said, the rule of law is fundamental to peace, to security, political stability. It's essential in promoting economic and social progress, and in protecting the rights of the individual. And as I say, we've all seen instances around the globe we could probably reel off, in this current moment, we could probably reel off a couple countries where, the rule of law is seriously under threat at the moment. And we're fortunate to a certain extent in this country that, we have the rule of law underpins our democracy. Obviously, we have seen some of those rights eroded away over the last year in order to deal with emergency legislation, to deal with the pandemic, to deal with the pandemic and to deal with some of the issues. Are you still there?
Yes.
Sorry, I seem to have lost you. Can you still see me, can you?
Yeah.
Okay, I don't know what's happened there, but oh, there you are. You're back. So yeah, so we've seen some of those rights eroded away, if you like. Some of the some of the biggest encroachments upon our civil liberties over the last year to deal with the restrictions that have been put in place to deal with the pandemic. But the rule of law is still very much a tenet of our democracy, of our society. So it really does have a role to play. And of course, Parliament is currently debating whether or not, further restrictions are needed to deal with the pandemic. So some people may say, well, actually, the rule of law is being eroded in this country. And we have seen some of the rhetoric coming out of parts of government that hasn't been helpful in its description of lawyers, and description of those who are upholding the rule of law.
Thank you. I suppose this is a question for both of you. What are your opinions on legal aid and the recent legal aid cuts in the UK?
In my perception, and I speak as a barrister and then a judge, I regard it as extremely regrettable the way in which legal aid is being cut, because I believe fundamentally in as level a playing field as possible and an academy of excellence. That said, what matters is that people are represented by able lawyers, and I think the public may take a rather jaundiced view of the fat lawyer who is making lots and lots of money with legal aid. What the problem with cutting legal aid is you are exposing the potential for erosion of protection. And I say that in this context, it really harks back to what you were just asking about. The checks and the balances. Judicial review is so very, very important in terms of accountability. And to the man and woman in the street, complex rule of law is something they probably don't really think of on a day-to-day basis. And if asked to say what it was important for, they might scratch their heads. What everybody wants is fairness, and that is the beauty of our system and our democracy. And I think fairness is achieved partly through accountability, and accountability requires money. And if you cut legal aid, you are cutting off the routes for some people to ensure accountability. And that is, I must stress, that is a very personal view. I don't speak on behalf of the judiciary when we say that. But access to law is as important as the rule of law, is my perception.
Absolutely. And I would just add to that, absolutely, legal rights mean absolutely nothing if you don't know when those rights are being taken away, or you're not able to enforce those rights. And of course, going to signposting individuals to a lawyer and knowing when to go to the lawyer and being able to afford to go to a lawyer is one of the tenets of our society. And so the cuts, the underinvestment over the years by successive governments into our public funding system, the Law Society and others continues to lobby government, and we welcome the amount the money that has recently being directed towards legal aid. However, it's not enough. And we welcome the Ministry of Justice's review into criminal legal aid and the civil legal aid and the legal aid means test review. But we are very clear that further investment to erode the years of underinvestment and cutbacks that have been systematically imparted into the system over the years needs to be addressed. We need to have a properly funded legal aid system that enables individuals to enforce their rights and exercise those rights, and not, access to justice should not be about people's ability to pay for that. So it shouldn't be a preserve of the wealthy. It should be, we should have a properly funded legal aid system that people can, as I say, exercise and enforce their rights when they need to.
Thank you, Ms. Boyce. Our next question from Katie is how would you actually? So there's been a double question here, and it's just come through as the same question. What's you got next? Your next question.
Okay. In terms of impartiality, Judge Darling, how do you manage to keep your social, economic, and political views out of your rulings and viewings and judgments of each case?
That is a very, very good question. And I try very hard, but it depends. It will vary from situation to situation. And if my views become apparent, it shouldn't really surprise people. But the views that I have must be in accordance with the law. In deciding a point, I reach a conclusion on the arguments I've heard, and that must be logically justifiable. And I can't do that if I allow my own personal bias to thing. And one of the strange things, people don't really believe when I say it, I am one of the most unjudgmental people you can ever come across, because I think judges sort of do have to be unjudgmental, you see what I mean, so that they can come to something without a preconditioned approach. And my mind, I hope at least, remains open. I try not to let the different aspects of my life cross over and blur what needs to be clear lines between them. It's hard work. It's not easy.
Some politicians and some political figures have openly criticised judicial review. They've talked about possibly axing it or changing it in some way. Do you agree with this opinion that judicial review should be replaced? Do you think it should be reformed, or do you think it's fine the way it is?
From the higher courts aspect, it's a poison chalice. Judicial review is essential, as I've already said, in terms of accountability and fairness. But one of the problems is that judicial review can attract extremism and people who have their own axes to grind, as opposed to having genuine questions of the legal process. And it's a balance that has to be struck. And I think funding is part of that balance that governments, successive governments, have looked at and have wondered if by making judicial review slightly less available, slightly more inaffordable, or rather more expensive to do, whether or not that would cut out the crackpot. And I don't mean that disparagingly per se. And I don't know the answer, but I think judicial review has to be maintained, because otherwise we are creating a fluidity in what is supposed to be a visible, transparent structure, and judicial review is the heart of it.
We've got a question in. Would either one of you support a move towards a written constitution?
Well, I guess this is it. This would be in my personal capacity. I mean, I certainly studied the Constitution and had the privilege of being taught by the great Professor Vernon Bobnador, who is quite prolific on the British Constitution and the merits of a written and unwritten Constitution. I mean, obviously, we've seen the pros and cons, if you like, of a written Constitution as that set out in America. And the last rounds of constitutional interpretation by the then president. I guess at the end of the day, some people have said our uncodified constitution has done us well. Some people have called for it to be written. Some people take the view, if it's not broke, why fix it? I'm not sure I have a clear view on it, other than I think it's placed us in good stead for since for the last 800 years or so. So we've fared quite well in comparison to those who have had a rigid constitution.
I think also it's follow on from that, and Steph is absolutely right, and I agree. I don't have a fixed view, but
it's 19 hours.
When the Human Rights Act came into force, everyone was terribly excited about how this was going to work, and we all had to go off and do courses and learn about human rights, and people became human rights lawyers in bizarre little niches. And gradually, as the dust settled, people realized that it was the implementation of the fundamental sense of fairness that underpins our legal profession, the right to a fair trial. Well, those are the things that maybe we take for granted in this country. But as Steffi says, if it ain't fixed, if it ain't broke, don't fix it. I don't. Yeah, that's all I have to say.
Another question for both of you. Would either of you be in favour of changing the judiciary to possibly becoming the highest authority over Parliament?
Absolutely not. Absolutely not. That would fundamentally destroy the democracy that we have in terms of the separation of powers. The executive is the executive, and the judiciary, as it were, are the guards at the gate to make sure that things are lawful. Providing it's lawful, people can be left wing, right wing, providing it's within a framework that we recognise as being our law. Then I would see no basis for the judiciary taking over the supreme role over the executive.
Do you have any more questions from the audience or
the audience? Just one question from me, if I might, as I swing in here, stage whatever.
Right.
I'm interested in the Human Rights Act. You mentioned it there. It does seem that every now and again it becomes fashionable to have a bash at the Human Rights Act. I was interested. I was reading the other day about an English Bill of Rights. Do you have any understanding of what that would look like, how it would actually differ from the Human Rights Act, and whether or not that should be something we should welcome? Sorry, 3 questions there to finish off with, I think.
It's fairly removed from the cold-face world of the circuit judge, but I'm not sure what an English Bill of Rights would look like, because I can't ever envisage any sort of enactment that would depart from the level of fairness that we just take as read. And we all know, it's what I said before about one of my prime responsibility is to be fair. And although people may not be able to phrase it in terms of the academic terminology, people know fairness when they see it. and that's what the Human Rights Act is. It is a less rigid version of for example, we're talking about America or other countries, but providing we have independence of the bodies, it's like a machinery. It just works in harmony. But as far as a specific English Bill of Rights, I'm not entirely sure how that would look, unless I went back to running meetings.
Well, thank you so much to both of you for talking to us today. It's been very insightful and very interesting.
Well, thank you. It's been a pleasure.
Absolutely. Well, thank you very much for inviting us. One thing I should say is that you made reference earlier to me becoming president later this year. In fact, I will become president this Friday, so earlier than expected. And I hope that with restrictions being lifted, that either I, and certainly I'm sure Ian as well, that we can either come to visit Stowe School, or indeed you guys will come to Chancery Lane to visit me. But thank you very much for inviting me to speak.
I echo those words. I suspect I might be slightly less welcome at Stowe than Stephanie. But I intend to try and set up, should there be any interest, a marshalling scheme so that Stoics can come and sit alongside a judge and see it from that side. And it's very different and quite enlightening. So and should there be any further legal talks or whatever, I'm more than happy to oblige. In pleasure.
Well, that'd be great. Thank you.
Pleasure, son.